just over here so I can look at this screen. Okay, thank you very much, folks.
Yep,
Okay.
you're right.
If the council, unless you guys object, I'm going to remove my mask just so I can speak a little clearly, and hopefully everybody can hear me both in the room and also on Zoom. So the first thing I want to do, as the mayor said, is give a little bit of a background about affordable housing, about the system that we have in New Jersey, just so that folks have a good basis for what the council is going to be considering this evening with the settlement agreement. So where I'd like to start is essentially, what is affordable housing in New Jersey? Fundamentally, it is housing units that are reserved for low and moderate income households. That means households or housing units that are most often deed restricted for a minimum of 30 years to ensure that they can only be occupied, whether they are for sale or for rent, by households that meet one of the various income guidelines that I have up on the screen. And so what you can see is the three different types or levels of affordable housing. That's moderate income, which is 80% of median income, low income, that is 50% of median income, and very low income, that is 30% of median income. And just by way of example, I wanted to share a couple average salaries here in New Jersey that based on those average salaries would qualify for a low or a moderate income unit here in Millburn. So consider, for example, that home health and personal care aides, their average income is just shy of $29,000. And based on this chart that I have on the screen, that means that that average income would qualify, that person with the average income would qualify for a low income unit here in Millburn. Similarly, nursing assistants have an average income of about $33,000. And cashiers have an income of about, on average, about $27,000. And then the last example I wanted to give is waiters and waitresses, which have an average income of about $30,000 a year. And so these are all examples of occupations that we have here in Millburn, as well as in the surrounding region, that qualify for low and moderate income housing. And so what this really translates to are restricted rents and sales prices. So if you qualify for a low or moderate income housing unit rather, this means that your rent will be held at one of these approximate values that I've placed up here. So a 2-bedroom rental unit that's affordable would rent for between $600 and $1,300 a month. And that pretty significant range is based upon the range of the income, the very low, the low, and the moderate income I just went through before. And similarly, a 2-bedroom for sale affordable unit would be sold for approximately between $70,000 and $175,000. And again, that's dependent on whether it's a very low, or moderate income unit. So there is a lot of history to affordable housing in New Jersey. And I will not go through all of the details because that is a presentation in and of itself. But I think it's important that folks understand why we're here tonight, why Millburn has been tasked with addressing this monumental challenge. And frankly, it all goes back to 1975, when we had a very critical court decision for the development of New Jersey. And that is referred to as the Mount Laurel 1 decision. And it, at its most core level, it is the New Jersey Supreme Court finding that every municipality in the state has a constitutional obligation, as in related to our New Jersey Constitution. They have a constitutional obligation to provide opportunities for low and moderate income housing development in their community. That case, there was another iteration of that case, essentially, Mount Laurel 2 decision, again, New Jersey Supreme Court. And at that point, the court provided some more detail. And rather than just simply this amorphous obligation to create opportunities, it identified that municipalities should have specific obligations. So an actual number of affordable housing units that need to be created or need to be given an opportunity to be created within their municipality. And so what that did was it really created a scramble for municipalities to try to come into compliance, to create affordable housing plans that would provide for the correct number of affordable housing units. What it really led to is frankly chaos. And so the New Jersey legislature finally stepped in 1985 and gave us the Fair Housing Act. And that's important because that's the act that everything that we're working on today is based upon. So when I research affordable housing in New Jersey, I'm still going back to this Fair Housing Act that started and has been amended several times, but started in 1985. That Fair Housing Act also created the Council on Affordable Housing. That is the state agency, often referred to as COA. That's the state agency that is supposed to implement the Fair Housing Act. What does that mean? It means they're supposed to create affordable housing obligations. They're supposed to create rules so that towns can figure out how to comply, how to meet that obligation. And they're supposed to provide administration and enforcement. They are the intended recipient of municipal housing elements, and they would review them and presumably approve them or work with the municipalities until they were eligible to be approved. That worked pretty well for from about 1987 through 1999. COA issued rules, they issued obligations, they approved municipal plans, and things really started to fall apart in 1999. It started with a delay in the agency issuing rules. And then they issued rules in 2004, also in 2008. However, they were struck down time and time again. The agency was tasked with developing new rules, and it all came down to a moment in 2014 where there, for reasons I won't get into this evening, but the bottom line is the agency could not adopt the rules. There was literally a 3-3 tie, and what that meant was the rules were not adopted. There was some litigation afterwards, and that's when we had our 2015 Mount Laurel Court decision. And that is a key point in the process that we're in today, because in that decision, our New Jersey Supreme Court essentially found that the state agency COA was no longer functioning. They couldn't be trusted to produce those obligations, to produce the rules, and to do the administration of municipal housing plans. And what the Supreme Court said was, on one hand, they said, please, state agency, please fulfill your role. But if or until that happens, all of this needs to work through the New Jersey courts, through superior courts. And so what that means is instead of Millburn working with our intended state agency to produce an affordable housing plan that would be compliant, we are now forced to work through the courts. That means we have to work through this process that I'm going to go through in more detail this evening, and do so through the courts, which is a more lengthy, complicated, and frankly costly process to municipalities. But what does all this mean besides simply the courts stepping in? What it means is that affordable housing in New Jersey is state mandated. It means that we have direction from first from the New Jersey Supreme Court, then from the state, well, from the legislature through the Fair Housing Act, and then through the state agency, COA, when they were functioning, and now again from the courts for municipalities to produce compliant affordable housing plans. And it's so important that towns do this because there is a major incentive. There's a significant incentive for doing so, as there's a cost for not doing so. And that cost is a lack of control, and it is being potentially subjected to builder's remedy litigation. And that's something that a lot of municipalities, including Millburn, is familiar with. And that is simply, could be quickly summarized as a developer stating that a municipality has not fulfilled its constitutional obligation to provide low and moderate income housing. That developer then offers to provide assistance to the municipality by creating an affordable housing development. Those developments look different depending on what town you're in, but the characteristic that seems to tie all of them together from Essex County all the way down to Salem County is that it is a building or buildings that is too much for the municipality's vision for that site. It's too dense, too tall, too big, too much. And because the developer has presumably been successful in showing that the municipality is exclusionary to low and moderate income households, they are not providing this opportunity that is required by the Constitution. The developer is oftentimes successful in seeking approval, court approval, and then required municipal approval for that building or buildings that are just simply too large. And that very significant incentive is the thing that typically drives municipalities through this process. Because to be subjected to builder's remedy litigation, it means a fundamental loss of control over your municipality. It means your zoning is irrelevant. It means your master plan vision is irrelevant. And then frankly, if you do go through the builder's remedy process, what's typically required is that you produce the housing plan anyway. And so there's ultimately no escaping this state mandated requirement to produce the affordable housing that's necessary. And so what I want to be clear about is who we're dealing with in the settlement process. So certainly it's the state of New Jersey from the perspective that they've adopted the Fair Housing Act, but it's also more directly, it's the courts. We're working directly with Essex County courts to help administer this process and then hopefully to approve a settlement agreement that the municipality may enter into and approve a housing plan that we may adopt to enforce or rather implement that settlement agreement. But beyond that, we're also working with advocates, and the principal advocate is Fair Share Housing Center. They are a critical organization in this process here in Millburn and in literally every other municipality in the state that's gone through this process. They are essentially a court-appointed or court-recognized interested party, and that means that they are on the other side of the table in mediations about what the municipality's affordable housing obligation is and how it will be satisfied. And just for a little context in the history, they're the organization that has pushed the court to ultimately issue that 2015 Supreme Court decision, pointing out that the state agency was not fulfilling its role. In addition to mediating with Fair Share Housing Center, we're also working with the special master. That is a planner. Almost always a planner, but here in Millburn, a planner that has been appointed by the particular judge to assist him or her in this process. That means that they serve as mediator, they serve as a guide to the municipality in crafting the affordable housing plan. They also provide assistance to the developers if they're involved in the case, and of course they assist with the judge's evaluation of the municipality's action and their fair share plan. And then last, but certainly not least, is obviously the municipalities, as it is our obligation that is assigned and our responsibility to satisfy that obligation. So we started in 2015 when I said we had that Mount Laurel 4 decision issued. Since then, approximately 330 municipalities in the state have gone through this process. They've filed they've filed what's referred to as a declaratory judgment or otherwise become involved in the process, perhaps through builder's remedy litigation. There are all but about 5 towns, including Millburn, that have settled. And that's critical to understand because I think that's part of the reason why this process, why the settlement has come to a head so rapidly. One of the things we'll talk about is what happened in the last month or so with the courts and increasing pressure on Millburn to go ahead and settle its housing plan. So in 2015, perhaps uncoincidentally, the township created its first affordable housing project, and that's actually referred to as the Upton Inclusionary Development, or the Upton. It's on JFK Parkway, so folks may be familiar with it. In 2018, this municipality was actually subjected to a builder's remedy litigation, and that's for the Silverman site. It's at or sometimes referred to as the Woodland Chatham site, based on the intersection that the site what happens with the municipality? We were subjected to a builder's remedy. We did ultimately settle with them, but that's an example of where Millburn faced this challenge with the developer. And that really kicked off this process for us. Once we got through the immediacy of the builder's remedy, the municipality was able to get immunity from future builder's remedy litigation, which is truly important to any town that's going through this process. And from then, we began our mediation. We began our settlement process working with Fair Share Housing Center. And from 2018 into 2019 and through today, our negotiations with Fair Share have continued. It's been, I think I can estimate, it's got to have been hundreds of hours that have been spent working with the organization as well as the developers that have been involved. Those developers are actually two parties that became interested parties in our process, meaning that they are recognized by the courts, and ultimately the court pressured Millburn to settle with not only Fair Share Housing Center, but also our two interested parties. The first one is Woodmont, and the second one is 249 Millburn Avenue, sometimes referred to as the Annie Says site. And so it got to a point where the court gave us approximately 3 weeks and said, Millburn will settle or the township will lose immunity. And it was, that is a very scary proposition for any municipality, especially a town like Millburn that has at least two developers, Woodmont and Millburn Avenue, that are literally standing there waiting to either have a settlement put in place for their development, or in the alternative, I have to assume to take advantage of the builder's remedy litigation opportunity. And unfortunately, there may have been other developers or property owners waiting as well. The municipality took that direction from the court very seriously, and settlement negotiations were expedited. And as we all know this evening, a settlement will be considered. I want to talk a little bit about the obligation generally. The first thing to understand is that there are three components of every municipality's obligation. The first one is the rehabilitation obligation, and that is an estimated number of substandard units in the municipality that are occupied by low and moderate income households. It is an estimate based upon data sources such as the census and the American Community Survey. It is not a reflection of somebody driving through this community and identifying substandard units. The second component is the prior round obligation. And this is the obligation from 1987 through 1999 that COA administered. They calculated these obligations. They put in place rules for municipalities to help satisfy those obligations. That number remains in place and is something that every town needs to address. The third component is the third round obligation, and that is the obligation that addresses that from 1999 now all the way through 2025. It is essentially a 26-year obligation, and it is the time that it applies to is noteworthy because it's so long. What that means is the obligation across the statewide and at the municipal level is really quite large, much larger than we were used to thinking about during the first round or the second round, which I should note are collectively referred to as the prior round. It's because of that 26-year obligation that the numbers have grown. So now I won't go through all the details, but I wanted to put this screen or this slide up because it shows the complication that this township and every municipality has to deal with. So yes, we have a prior round obligation and a third round obligation, and of course the rehabilitation obligation. But for the prior round and the third round, in addition to just simply finding a way to meet the total number, there are a variety of subcomponents of that obligation. It includes things like the 25% rental obligation, 50% family obligation, the 50% family obligation of the 25% rental obligation. There's also income distribution and bedroom distribution. obligation. And I should also say a limitation on the number of senior units that can be included in the municipality's fair share plan. So I don't want to, I'm happy to answer any questions about this at some point, but just, I wanted to put this up so folks have a sense that this is unfortunately quite a complicated puzzle that municipalities have to find a way to meet. This slide depicts the various affordable housing obligations that have been calculated for Millburn. And there's a slide like this for every town in the state, or could be anyways. The numbers all the way on the left represent the obligations calculated by COA in 2008. And those obligations went from, I believe, 1999 through 2018. And the state agency, using their own methodology, calculated a number for the third round in particular, as you can see, is quite low at only 67 units. Now, I should say that obligation, or rather the methodology that produced that obligation, has been thrown out by the courts. That is part of what the court had overturned during COA's attempts in 2004 and 2008. Moving on, we have an obligation produced by eConsult, and that was an organization that worked on behalf of municipalities to calculate municipal obligations. That number, and then next, second to right, is the Jacobson decision. That's an important number because that represents the methodology and then the resulting affordable housing obligation that was determined by Judge Jacobson in Mercer County. Now, her decision technically only applies to 2 municipalities in Mercer County, but it is such a well-regarded decision. It was argued so thoroughly that it has become a number that many municipalities and Fair Share Housing Center in settlements have come to rely upon for determining municipal third round obligations. The number on the right is Fair Share Housing Center obligation. That's the number that their experts produce. Now, I should note that the Judge Jacobson decision essentially decided between obligations being argued by Fair Share and obligations being argued by eConsult. And so, as you can see, her obligation for Millburn is 1,115 units. And clearly, it skews a bit towards Fair Share, as their obligation was set forth at a little under 1,400, while eConsult's obligation was a little over 500. And so I thought this slide was important because it shows the range of third round obligations that have been calculated by the municipality. And I think it also highlights the importance of why we chose to consider settlement, because one of the benefits of going through the settlement process is typically that a municipality receives a lower third round obligation than might have otherwise been assigned during a trial. So as we see here, I've got a summary of some litigation risks and some benefits of settlement. The litigation risk, as I've talked about, is, I think first and foremost, it's the loss of immunity. It's the loss of control over our planning and zoning, and it's the loss of control over specific sites. And so by settling, we're able to maintain that control. That means that we produce our housing element and fair share plan, we determine the zoning, and frankly, we're not subjected to builder's remedy litigation. As I said, through settlement, municipalities typically receive a lower affordable housing obligation, both at total obligation and if there's any adjustments, such as a vacant land adjustment. And then lastly, the last point I want to identify for litigation risks is that there have been some municipalities that have decided to go through this process and have decided that they're unwilling or unable to settle with Fair Share Housing Center, and they've decided to hold a trial. And that trial typically has to identify what the affordable housing obligation is and what the plan is to satisfy that obligation. So what sites will be selected, perhaps what densities will be utilized. I can't tell this municipality that any town that has gone through that trial process has actually done so successfully, and that they've come out in a better position post-trial than they would have through settlement. It is a long and a costly and a sort of painful process, if you will, And at the end of the day, the obligation and the strategies, I'm confident saying, are more demanding, more density, more demanding, and however a municipality might want to measure it than they might have been through the settlement process. And so through the settlement, we were able to gain these benefits. And as part of it, it also means that we are settling about 50 years of affordable housing litigation. 50 years meaning from the time Mount Laurel 1 decision came to be in 1975, all the way through the end of the third round in 2025. And so that's 50 years. It means that we are able to put to bed this risk of builder's remedy litigation through the end of the third round. And so with that, that's an overview of the affordable housing process and affordable housing in New Jersey. And I'm happy to answer any questions.
Just before we get to public comment period, Mcmanus, can you give us a background about who you are a little bit more?
I'm sorry.
No,
Yes.
all right. Just so everyone knows, where all your wealth of information is.
Yes, okay. My name is Elizabeth Mcmanus. I'm a principal at Kyle McManus Associates. We're planners down in Hopewell, New Jersey. I've been working in municipal land use in New Jersey in 2001. Most of my time has been spent working for municipalities. And during that time, I've been working on affordable housing since I think about 2004. I think my first plan was in 2005. So one of those first versions of the COA third round plans I started working on. And since then, I think I have authored either as the sole or maybe even secondary author when I was younger of more than 24 housing plans across New Jersey. I am also special master. So one of the roles I talked about for Millburn is special master. I actually fulfill that role for about 40 municipalities across the state through this current process. So I have more affordable housing experience than sometimes I like to remember.
Okay. So we're gonna start public comment period on just this presentation that was just given to us. To help facilitate an orderly meeting and to permit all to be heard, speakers are asked to limit their comments to 1 3-minute session into regards to this presentation that Mr. Mcmanus just gave to us. You will be prompted when there's 30 seconds remaining, and after the conclusion of the public comment period, your questions and comments will be addressed. So as we normally do during public comment at all of our township committee meetings, you'll have an opportunity to ask your questions, and then when the public comment period is done, then Ms. Mcmanus will answer your questions. And we also have the Zoom we're going to bring back so that we can have participation. Please.
This protocol, when we speak, can we remove our masks? We want to protocol. Can you hear
So
us?
we will do that, right? So you
Yes,
can
I'm
take
just
your
asking.
mask off when you're speaking.
I just wanted to, everyone that has protocol. Again, my name is Jeffrey Feld, live in Alexander, on Short Hills, New Jersey. I had just a few short questions. One, I was troubled by a comment that was made about the court saying, to paraphrase you, you will settle or you'll lose your immunity. And that's a statement I think that had been made in early July, but that was never told to the public when there was reports given to us by municipal. I'm very troubled by that lack of candor that the court basically say, settle or you're going to lose immunity. That was an important point that was told us, I guess, to us in July, but it was never told to the public. In addition, when I started appearing for this group in like September, October, I talked about best practices. And in the best practices that come out from the state, it talked about the need for inclusionary zoning ordinance. Based on this town's response, we don't have one. And that was not mentioned in the report, that we haven't been involved. And I think the public also needs to know, with no due respect to you, Ms. Mcmanus gave a proposal to the town on July 6th. And I think everyone should understand how short your involvement has been with this community. I think you were retained at the meeting in July, so you've been only involved in this little like 5 weeks. And I think you really brought us up to speed. However, I think the public should know, when you gave us the chart, starting with the original style, the Jacobson report, like the 4 columns, can you tell the public, when we filed our declaratory judgment, what numbers did we use in those 3 categories? Because later tonight, we will find out where we started in April 2018, and where today, on August 17th, where we were. And then there'll be questions, because there are a lot of serious questions. What transpired in the last 3 years? I've been on really focusing on the last year, but there seems to have been 3 years that you said there were 5 communities. Who are the other 4 communities? So that the public knows who we are grouped with. And that could help us. But I thank you for the overview. But if you could tell us, where we started in April, that'll help us later this evening to understand, did we go anywhere? Where we went? Because I don't know the answer to that. And we're all waiting for the opening of the envelope.
Please, please.
The answer and then question. My name is Dave Cosgrove, 99 Oakview. So the question, I have 2 questions, really. One is, when were you asked to prepare this presentation? When were you first asked to begin preparation? And the second is, the slide you showed us with the housing business. That's nothing new. That's my question. That's years old, isn't it?
Mr. Cosgrove, we're going to do
Okay,
this as we do
that's the
regular
question.
public comment, and Ms. Mcmanus will answer all the questions at the end.
Thank you.
Okay, thank you.
Jean Pasternak, 342 Hobart Avenue. I just want to add a little history for Ms. Mcmanus that you may not have been privy to. Public interest advocates and developers filed lawsuits against many municipalities that had not done their fair share. No advocate group or developer filed a lawsuit against Millburn until April 16, 2018, when the builder's remedy lawsuit was filed by Silverman for the Woodland Chatham development. The Township Committee in 2017 consisted of Ms. Burstein, Ms. Eglow, and Mr. Levy, Democrats, Rosenberg and Tillotson, Republicans. Silverman was in talks with majority members of the Township Committee regarding Woodland Chatham Road development. An agreement did not seem to be forthcoming. Silverman was becoming unhappy with the lack of response. A builder's remedy lawsuit would force the township to allow that development. I wondered, why did no one instruct the planner to prepare and submit a fair share plan to protect the township from an impending builder's remedy lawsuit? The Township Committee of 2018 was Burstein, Lieberberg, Eglow, Levy, Democrat, Rosenberg, Republican. It was reported that Cheryl Burstein spent 2 years of discussions with Silverman regarding his development plans for the Woodland Chatham Road property. During that time, the Township Committee did nothing to protect the township by submitting the township's fair share plan to the court. That failure to take affirmative steps to protect the township ceded control to the builders. This Democrat-controlled Township Committee of Burstein, Lieberberg, Eglow, Levy, and Rosenberg filed a fair share plan 3 days after the Silverman's builder's remedy lawsuit was filed with the court, resulting in this irresponsible outcome. Thank you.
Anybody else in the room have any public comment at this time? If anybody on Zoom call, if you raise your hand, do you have any questions at this time? Good evening, Mr. Hiltner. Hear you.
Good evening. I'm having a little trouble hearing you. Can you hear me?
We can hear you. Yes, we can hear you.
Okay. I have one simple question. This covers affordable housing obligation from 1975 to 2025. What happens after 2025?
Thank you.
That's one question.
Okay,
And the other thing is, I have not seen the petition or complaint that was filed for declaratory judgment, but maybe there could be a brief explanation, or what are the parameters of a settlement? What are the elements that must be included in this besides the number of affordable units? What other kinds of considerations are addressed? Since I gather we're not going to hear the details of the settlement tonight. So, but what's kind of the menu?
Mr. Hildner, let me just interrupt you for 1 second there, because as we did mention that there's potentially, like, after we go through this, that the contents of the settlement, shall it pass, will be revealed. So I just want to correct you on that statement.
Okay, that'll be attached. Again, I'm sorry because I'm having a real hard time hearing you, but the settlement agreement will be attached to some kind of consent order, I assume. And if that's the case, what I didn't hear, what you may have just said, is when that will be available. Is that going to be available as part of this meeting, or is that going to be after the vote on whether or not to approve the resolution?
If the vote, if we take a vote to approve the resolution, the settlement, the contents of the settlement will be revealed. Can you hear me? Is that better?
Yeah, well, that was slightly better, but thank you for.
Okay,
Right. All right. Those are the only questions I had.
okay, thank you. Is there anybody else on Zoom that would like to make a public comment period? If not, then we will continue on. Okay, public comment is now over. We are now going to refer to special counsel at Muzak to explain a little bit more about this process. Mr. Muzak.
Thank you, Mayor and members of the Township Committee and members of the public. There are two items that I'd like to address for the Township Committee and the public. One that actually derives from some of the questions that came up, and that is the confidentiality aspect of this, and the mayor addressed this at the close of the public comment period. The township has engaged in mediation virtually from the time the declaratory judgment action was filed in 2018 in an attempt to resolve the matter. Those mediation sessions were declared by both the court and the mediator as being confidential. Everything that was done and everything that derived from those mediation sessions, including the ultimate settlement of this case, were all confidential.
Mr. Buzak, can you please speak up so that we can hear you a little bit better?
Yes, I
Thank
will.
you.
I will do that, and please interrupt me if you cannot hear me. Is that better?
That is better.
Okay. The mediation activities and the settlement agreement that were derived from that is and remains confidential until such time as it is approved by all parties. That was the order of the court and the order of the mediator. If the Township Committee approves the settlement, as the mayor pointed out, it will then become a public document, assuming that the other parties have signed the agreement. And I will leave that to your counsel, Brad Carney, to address as soon as I am finished. The second item that I'd like to address is a conflict issue. It has been placed on the record in the past that two members of the Township Committee have conflicts with regard to this settlement agreement, one being the mayor and one being Committeewoman Miggins. The basis for those conflicts have been made public, and I will not repeat them. It has now come to light that there is an additional conflict of an additional Township Committee member. Committeewoman Iglo has a conflict of interest that relates to one of the sites that is included in the settlement agreement. She is in proximity to the site in terms of residing. Her residence is in proximity to the site. She has lived in that neighborhood virtually all her life and remains in that neighborhood. The impact of that particular development in her neighborhood and given her proximity to it will, in her view, potentially affect the property value that she enjoys, and also her neighbors that she's grown up with and have known for years enjoy. Based upon that, she is of the view that disproportionate weight will be given by her to the impact of this settlement on her personal and financial involvement, as well as those of her neighbors, that will prevent her from looking at the entirety of the settlement with all its components as it affects the municipality in a fair and objective way, and to be able to make a dispassionate decision objectively. As a result of that, we now are placed, or the township is placed in the position where there are 3 conflicted members of a 5-member township committee breaking a quorum. We need 3 non-conflicted township committee members in order to conduct a meeting and in order to act on any business. So it creates a dilemma and a potential overall catastrophe for any further action on this matter. And this would occur whether it's Millburn or any other municipality in the state of New Jersey. Fortunately, there is a solution and a mechanism by which that catastrophe will be avoided. And for that, I'm going to pass it to the township's general counsel, Brad Carney, who's here as well on Zoom, to explain what that mechanism is and how it is going to be applied tonight. So, Mayor, I'd like to pass this to Mr. Carney.
Mayor and Council, good evening, everybody. I'm here in Kit Falcon's place this evening, and I'm a partner at the firm of Mariziti Falcon. And under a circumstance where 3 of the 5 members have a conflict of interest would mean that there would be no quorum available to vote on the settlement agreement. However, there is in the law a doctrine known as the Doctrine of Necessity. And that doctrine allows an official to participate in public business, notwithstanding an otherwise disqualifying conflict. Actually, Judge Serpentelli, in a case, Allen versus Toms River Regional Board of Education, held that the doctrine of necessity can be limited in circumstances where, 1, there is a pressing public need for action. And here we clearly have that because we have a court order filed and dated August 2nd with the township's immunity expiring at midnight tonight unless the settlement agreement is approved. 2, there is no alternative forum which can grant the same relief. Well, there's not. This is only before, it can only be decided by this governing body, this township committee. And the body, meaning the township committee, is unable to act without the members in conflict taking part, which is true because otherwise you'd be left without a quorum. So in light of the fact that you meet all 3 elements for the doctrine of necessity to be invoked, I recommend that it must be invoked here, which would allow the full township committee to deliberate and participate in the public business and considering the resolution this evening to either adopt or reject the settlement agreement.
Okay, thank you for all of that information. So with all of that being said, may I have a motion to approve resolution 21-236?
Motion.
May I have a second?
Second.
At this point, I'm gonna offer it up to any township committee members who would like to make a statement before we do a roll call.
Yes, I would, Mayor, if I may.
Please.
First, I want to thank Ms. Mcmanus for the presentation. It was really thorough and really informative. Thank you. We have a very difficult decision to make this evening. When each one of us up here decided to run for Millburn Township Committee, we all knew this was going to fall to us to ultimately decide and vote on Millburn's fair share housing settlement or choose to go to litigation. A very long and very expensive ordeal, which we have been told is not a winning move. As former Republican mayor and then turned council member, Tillotson said, Millburn has kicked the can down the road. Well, all of the former can kickers are gone. And now we have the responsibility to do what we think is best for Millburn. When I was mayor, that township committee had to vote on the Silverman Chatham Road development. Ms. Miggins and Mr. Wasserman were yet not elected. They both spoke about that settlement and how vehemently they disagreed with it for whatever the reasons they had at that time. They were not yet privy to the workings of fair share housing and just how little control the township actually has. I think it's fair to say they see things through a very different lens now. So let me be clear, tonight is not unexpected. What was unexpected was the time frame that the judge and fair share housing put on us in the middle of the summer and with the resurgence of the pandemic. Some of you here and watching tonight may think we had the freedom to publicly share and discuss what happened during the mediation sessions. Mr. Cosgrove, you even wrote to the mediator. I want to stress that I was not on.
Mr. Cosgrove, please don't respond back. We're just,
I want to stress that I was not on nor part of this year's steering committee that worked with fair share housing. After committee members Miggins and Wasserman would meet with fair share housing, the township's lawyers, planners, the mediator, the developers, and their lawyers, I would then hear what was discussed and in essence preliminarily agree to, and what would be brought to the full committee to vote on. I did not have much input to this final settlement. In fact, the contrary, many of the things I thought should have been in or out were not accepted by some members of this committee. This is not my final deal that we are voting on this evening. This is what committee members Miggins and Wasserman worked on very hard and diligently to reach our fair housing settlement this evening. Thank you.
does anybody, please, let's just remember not to call out during the meeting. Let's be respectful. So, does anybody else want to make a statement?
Mayor, I can go next.
Okay, thank you.
Thank you, Mayor. And as Committeewoman Eglo mentioned, that it's a tough decision. It is more like, it's not even a decision. We have to do this is what I'm getting it as. It's not that we were not agree, but even Committeewoman Miggins and Committeeman Wasserman being on the steering committee, I don't think we overall had any say. It was pushed on us. When I say us, all five of us, to have to do this or go into litigation. And just for that sake is what my vote will be on. Thank you, Mayor.
Thank you.
Thank you, Mayor. At this regularly scheduled meeting of the Millburn Township Committee, the committee will vote on a resolution to ratify a settlement agreement on the matter of state mandated affordable housing. The settlement includes a plan that outlines the construction of state mandated affordable housing in the township. Members of the Township Committee and a steering committee dedicated to this issue, along with a variety of Millburn leaders invited to participate in this process over the years, have had an opportunity to weigh in on this important subject. Just last month, we think the date is July 15th, Millburn was given an aggressive court-ordered deadline to settle this matter or face significant consequences. The historical context of this subject is important to understand. For the past 38 years, Millburn, for one reason or another, failed to address and meet its state-mandated obligations on affordable housing. As such, the court and other involved parties through pending legal actions recently presented this. Oh, sorry. For the past 38 years, Millburn, for one reason or another, failed to address and meet its state-mandated obligations on affordable housing. As such, the court and other involved parties, through pending legal actions, recently presented this township committee with the following choices: further litigate with no real chance of prevailing, or negotiate the best possible outcome and settle. In that regard, and as you will hear this evening, this settlement agreement, which reflects many of the township committee's priorities on managing density in Millburn, represents the best possible outcome for the township. We are here to share details of the settlement with you this evening after being prohibited from doing so by the court throughout the negotiations. Affordable housing is mandated by the state of New Jersey, enforced by the courts, and essentially required by the state constitution. There is no opting out for municipalities. Municipalities all around the state, including neighboring towns of Madison, Chatham, and Livingston, have dealt with affordable housing mandates for years. It's important to understand that the entire affordable housing process, methodologies, calculations, orders, and timelines is sanctioned, enforced, and driven by the courts. You will hear more about other parties involved in the issue from the township's retained experts. But the bottom line is this: every 10 years or so, municipalities are required to meet court-sanctioned affordable housing obligations, which are specific numbers of affordable housing units that a municipality must provide a realistic opportunity for developers to build or face significant consequences. Given Millburn's long delay in meeting its state-mandated affordable housing obligations, this matter came to a head for Millburn and the Township Committee just in July. These were our choices: litigate further with little chance of prevailing and risk losing control of the township's planning and zoning functions and existing regulations, setting the stage for even more developments with affordable housing. Or two, settle and maintain control over all development in Millburn, including state-mandated affordable housing. We also maintain control of the township's planning and zoning function and existing regulations. And with this agreement, Millburn is, at long last, able to meet its past and current affordable housing obligations spanning the period of 1987 to 2025. And, as a final note, I will tell you that as somebody that was involved in this for hundreds of hours, in these meetings, we really did the best we could. We worked hard at this, and we really fought as hard as we could for the township. And that's all I want to say about it.
So with that, can we have a roll call vote, please?
Ms. Miggins,
Yes.
Ms. Saul Eglo,
Pass.
Mr. Vinayak,
Yes.
was that a yes?
Yes.
Thank you. Deputy Mayor Wasserman,
Yes.
Mayor Prupus,
Yes.
Ms. Saul Eglo,
Yes.
thank you.
So at this point, I'd like to again introduce our affordable housing planner, Elizabeth Mcmanus, who will now be providing the overview of the settlement agreement.
Okay, hello again. Well, now we're down to 4 communities in the state that are unsettled, and I'm pleased to see that Millburn is not one of them. Subject to court approval. I do expect that that settlement agreement will be approved. Just for reference, I don't think there's been one in the state that has not been approved by the court. Thank you. So the first thing, before everybody focuses on the numbers, sorry, I just want to give an overview of what's in the settlement agreement. I'm going to go through a lot of the details, but there are dozens and dozens of terms, and we would be here till about 1 in the morning if I went through every single paragraph. So today we're going to go through an overview, answer some questions, and additional information will be available at a later point. But most importantly, what's included in the settlement agreement? It's what is the municipality's affordable housing obligation? How are we going to meet that obligation? Meaning, what are the strategies? What are the sites that will contribute affordable housing units? And there are typically terms associated with those strategies. Maybe it's simply just the density and the affordable housing set aside, but sometimes there are details about how the site needs to be implemented or constructed, or perhaps when, with timing. And then there are a variety of other terms that deal with compliance. If folks remember, I had that slide that dealt with the rehabilitation and the prior round, third round obligation. And then it went into, there's a rental obligation, 25% rental, there's family obligation, bedroom distribution, income distribution, etc. There are terms throughout the settlement agreement that address those individual components. And then the last topic of the settlement agreement is about the implementation of the plan. So while this is a monumental step for the township, I have to say we're really not done. So we approved the settlement agreement. At that point, and I'm going to go through the details, we have to do a fairness hearing for approval of the settlement agreement. But importantly, the municipality has to take the various steps that are outlined in the settlement. That means things like rezoning and adopting a housing element, fair share plan, and all the documents that go along with that. And so the settlement agreement spells out what those items are and the timing for doing so. And so with that, let's talk about what's in the settlement agreement. So like I said, first and foremost, it talks about what is the affordable housing obligation. And so this slide should look pretty familiar as it goes through the various obligations that have been calculated by the different experts. And so what I've done is highlighted in red and also yellow what the obligations are for the municipality. So what you can see is, and actually I want to, one more reminder, even though I have the COA 2008 numbers there, it's really just for information and background. They are not applicable. They have been overturned by the courts essentially multiple times. So we have the 109 unit rehabilitation obligation. That is the lowest available number, the lowest available calculation. The 261 unit prior round obligation, as you can see, that is the same number calculated by every single expert, and that is because COA actually did that calculation essentially back in the 90s during its well-functioning years. And then our third round obligation is an obligation that is consistent with the Jacobson methodology, that Mercer County decision I went through with folks during the earlier presentation. It was such a well-regarded decision that it has become the basis for a lot of settlements here in New Jersey, including Millburn. And I think importantly, that obligation of 1,115 units is significantly less than the Fair Share Housing Center calculated obligation. So what that means is for our 3 components, we have 109 unit rehabilitation obligation, 261 unit prior round obligation, and 1,115 unit third round obligation. So first, and rather quickly, I want to talk about the rehabilitation obligation. This is an important component of what Millburn is being asked to do, but as we're going to see through the rest of the slides, I think it's a more minor obligation, if you will. So basically, municipalities are obligated to operate or participate in a rehabilitation program that simply provides advertising to residents of the municipality to let them know that if you are income qualified, if you are a low or moderate income household, you may apply to receive a grant or a loan to rehabilitate your home, to bring it up to code. Think of things like a roof that's in need of repair, steps, or maybe an ADA ramp that's in need of replacement or installation, these types of items. Municipalities in Essex County will participate, including Millburn, will participate in the Essex County program. The county, just like every county in the state, operates a rehabilitation program to residents within their county, just like Essex. So first and foremost, we'll participate in that existing program. Second, the township is obligated to create its own municipal rehabilitation program, and that is because Essex County, and actually all counties, do not make their program available to renter-occupied households, despite the fact that that is a required component in COA's rules. So Millburn, like many, many other municipalities, will have to create its own program available only for renter-occupied households. But the interesting part of our obligation is that we have an opportunity to conduct what's referred to as a structural condition survey, sometimes it's called a windshield survey. And essentially, that's an opportunity to reduce that obligation from 190 down to a number that is based upon observation in the community. It's a task that must be undergone by building inspector, construction official, staff member of the municipality, where they would literally drive through the community and identify units which appear based on a adopted checklist by the state agency to potentially qualify for rehabilitation. I will say that just because your house has been identified in the survey does not mean that the household is eligible in terms of your income, nor does it mean that if your home is not identified in the survey, that you are not eligible. It's simply another way of estimating the number of substandard units in the community that may be occupied by low and moderate income households. That is an option to the municipality should we choose to reduce that number. Our prior round and our third round obligations for the purposes of this settlement are essentially combined. So we have that 261 unit obligation for the prior round plus 1,115 units for the third round. I think everybody can understand that there is simply not enough vacant and available land in Millburn Township to build 1,115 affordable housing units plus market rate housing that may be necessary to accomplish that goal through inclusionary housing. And fortunately, there is a process set forth in COA's rules for municipalities such as this, for essentially built out or largely built out communities. It's called a vacant land adjustment, and it is essentially a theoretical or an academic exercise that municipalities go through to identify vacant and developable land and what their capacity is to accommodate inclusionary housing. Inclusionary housing, I want to define quickly, is development that includes a mix of market rate and affordable units. The set aside for calculating the RDP and the set aside that you're gonna see for many of your sites that I'm going to talk about tonight is 20%. So 20% of those units would be affordable, the remaining would be for market rate. And so we look at these vacant and developable lands. We also have to identify or include in this calculation any lot that will actually provide affordable units to meet the affordable housing obligation. When we collect these lots, we determine what the total capacity is and what the affordable housing set aside of those lots would be. A couple notes on this is vacant and developable lands are defined terms by the state agency and somewhat supplemented by case law. It is not a vacant and developable lot that your council may identify or perhaps the planning board or the public would identify. Instead, it's a regulated process set forth in COA's rules that any municipality that wants to take a downward adjustment of its obligation is obligated to follow. And so going through this process, it basically splits the affordable housing obligation into two items. The first one is referred to as the RDP, that's the realistic development potential, and that is the downward adjusted number, the downward adjusted obligation. for this township of both the prior round and the third round obligation. The difference between that total obligation and the RDP is the unmet need. And there are different requirements applicable to the RDP and to the unmet need. The RDP requires that municipalities identify individual sites that are currently available to produce affordable housing, meaning that they're vacant and they're developable, or that there's a developer standing there ready, willing, and able to redevelop the property. Unmet need mechanisms require a bit less. So rather than having a site that is potentially ready to go, unmet need is typically satisfied through overlay zoning and redevelopment opportunities, potential redevelopment opportunities. So there's very little, there's no expectation that a municipality is going to meet the entire obligation through unmet need. It's simply obligated to identify opportunities that may exist in the municipality, that may exist for future redevelopment and development. And so we'll see as I go through the individual sites, the different characteristics of the sites that meet the RDP and the different characteristics of sites that meet the unmet need. So what does all this mean? It means that the RDP is 114. It means that we took our large obligation of about 1,376, and through that vacant land adjustment process, we're able to reduce it down to 114 units. And again, that difference between the 1376 and the 114, that's the unmet need. And like I said before, unmet need is typically met through overlay zoning. That's the most, by far, the most common mechanism. So just generally speaking, and then after this, I'm going to go through the sites. Generally, what are the strategies that Millburn used, or what was the thought process for trying to meet that RDP? First and foremost, we want to use credits. We want to use the affordable housing units from sites that have already been approved. We want to get credit for the approvals that have already been granted so that we don't have to rezone additional sites. So we took credit from those properties, and I'll talk about those in a little bit. We also used all of our available bonus credits. Sort of a nuance of the rules I didn't want to spend too much time on, but there are certain affordable housing units that are eligible for actually 2 credits for every 1 unit that's created. It's capped at 25% of our RDP. This township took every bonus credit that was available to it, because for every bonus credit, it means 1 less affordable housing unit that needs to be planned. Additionally, the municipality discovered there are a couple of group homes in town. Group homes are living arrangements for folks typically, but not always, with developmental disabilities. They are often eligible for affordable housing credit. We're going to take credit for those group homes because, again, those group homes, which already exist in Millburn, lead to less planning, less new site identification. And then lastly, we wanted to take credit for our settlements with our affordable housing developers. One of the things I talked about during the last presentation was the court's immense pressure on Millburn to not only settle with fair share, but also with our 2 developers that were standing there and waiting. And so given the fact that we're required to settle with them, the municipality required that they produce affordable housing so that we could take credit for the affordable units created and thereby reduce additional development that's necessary to meet our obligation. The strategies for our unmet needs are necessary to be a little bit different just because of the nature of the sites and the considerations. First and foremost, and actually I guess this applies to our entire fair share plan, but the goal was really, how do we reduce development in Millburn? What strategies can we do to reduce the impact of new development on residents in the municipality? How do we simply reduce the number of new units that are zoned for as part of this process? As part of that, or rather, really in addition to that, one of the other goals we saw was to try to stay out of the residential neighborhoods. We want to have as little disruption to existing residential neighborhoods as possible. And then last, one of the components of the settlement agreement is adoption of something that's called a mandatory set-aside ordinance. And that is a township-wide ordinance. It First, it does not change the zoning districts, zoning densities, and it does not obligate your planning board or your zoning board to act differently. But what it does do is where the planning board, the zoning board, or this council through a rezoning or a redevelopment plan, where there's an approval through one of those avenues for new multifamily housing, there must be an affordable housing set aside with it. So if a D variant, a use variance for multifamily housing applies before the Board of Adjustment, the Board of Adjustment is in no way obligated to grant the variance based on this set aside ordinance. But if they do grant the variance, they need to impose a 20% set aside of affordable housing. It just simply ensures that the township captures opportunities for affordable housing wherever they become available. So this is our map that identifies the affordable housing sites in the township. Now I'm going to go through each one of them for those of you trying to crane your head to see exactly what's on the screen. But I wanted to put this up, one, just simply for context, but also I think this does a pretty good job of showing that the sites are not located within our residential neighborhoods. And instead, we've, to the extent possible, really stuck to our non-residential districts as a way to again, limit the impact on the township. So the first site I want to talk about is referred to as the Upton, or sometimes the Canoe Brook site. This is a site that actually already received approval and it's under construction. It's off of JFK Boulevard at 150 JFK Boulevard on block 5303. It's a little over 3.5 acres. And as I said, it's already been approved, and it's specifically for 200 housing units, including 30 affordable units, as well as a hotel and office space. The next site is the Silverman Property, which we had referenced earlier during the presentation, as this was your 2018 Builder's Remedy property. This site, as you can see from the plan, is located at the corner of Chatham Road and Woodland Avenue. And what you can see here is a concept plan that was developed by the developer. It is a mixed-use building. It's going to have a total of 62 units, including 12 affordable units, as well as medical office space of about 10,000 square feet. And this is actually the final image I have. This is the rendering of the property. So next, we have the Wells Fargo site. This too was actually already approved as well earlier this year. This is a property that's at the corner of Millburn Avenue, Essex Street, and also Douglas Street. It's a little over 1.5 acres. It received approval also earlier this year for 53 total units, including 8 affordable units, and then of course, 3,000 square feet of retail space. And this is not show as well as I thought it might on the presentation. I apologize for that, but that is the ground floor plan. You can see the outline of the building on the site. So this begins our new sites. The ones that I've reviewed previously have already gone through the site plan approval, and many of you may already be familiar with them. This new site is referred to as the Annie Says property. It's also referred to as 249 Millburn Avenue, both in name and also, of course, in its address. It's a little over 2 acres, and this was one of the sites that the court was requiring Millburn strike a settlement with in order to maintain our immunity into this month. The settlement for this is 150 total units, of which 30 will be affordable. So 30 will be available for low and moderate income. This is a concept sketch of the site. This is just simply the ground floor plan, but it gives you the outline of the building and indicates that there will be structured parking, as well as the building located generally along the street. This next property is referred to as the Dpw Site. And it is, in fact, the Dpw Site for this municipality. It's a little over 4.5 acres. It's located, as you can see from the map, off of Essex Street. This is, rather than being simply a inclusionary housing project where the municipality zones and a developer comes in and builds 20% affordable and the rest as market rate housing, Instead, this is what's referred to as a 100% affordable development or perhaps a municipally sponsored construction project. And so what the municipality has agreed to do is partner with a developer to construct 75 affordable units. So all affordable housing units on the site. And what that means from an affordable housing perspective is there's more bang for the buck in the sense that we're getting these 75 affordable units without the associated market rate development. More specifically, what will be necessary is that the township consolidate, or if it so chooses, to relocate all or a portion of its DPW on a portion of the site. One other component that is important, or a couple other components that's important to understand about this property is that one of the requirements of the settlement agreement is that we work with Fair Share Housing Center and with our planner, Special Master, on the design of the property to ensure that both the affordable units can be accommodated in a way that will ensure good quality of life for the residents of the site and still provides adequate space for the municipal facility for the DPW. In addition to simply working with them, we've actually got to work with them and do so successfully by the end of this year, by December 31st of this year. If the site, for some reason, is determined that it cannot accommodate both uses, the municipality has an option for will need to really, if the site cannot accommodate both uses, the municipality will need to identify another site by the end of February, by February 28, 2022. Presuming this is the property, the municipality, once we've been able to get through the design stage, we're going to begin working with affordable housing developers to construct the 75 affordable units. That means that we'll select the developer, we'll work with them on the concept plan, and then we'll work with them to ensure that they get the outside sources of funding, the federal funding that typically provides the financial support for these projects. And so what's important to understand about this site is that, yes, it's more complicated than just simply zoning a property, but it allows for the municipality to retain extensive control over the project in the sense that we'll have direct input on the design of the site. Obviously, we'll have direct input on what happens with the Dpw site, but we'll have input on the design, the developer selection, and exactly how they will interact with the municipality and how those site improvements will appear not only from within the property, but also to the surrounding community. Next, we have the Woodmont property site. Now, this site is located generally across from the Upton, also on JFK Boulevard. And so what you can see from this plan is that the site, which is about 25 acres, includes about 5 to 6 acres of developable land. And so what is anticipated, let me rephrase, what will be required is that the developer locate his or her development outside of the environmental constraint area closer to the highway of JFK Boulevard, Parkway, sorry about that. The site will contain a total of 195 units, of which 39 will be affordable. Now, this property is owned by the New Jersey American Water. And so what that means is that it is not as simple as the municipality simply rezoning the site and then the developer can apply for site plan approval. No, there are multiple steps required for the developer to actually gain ownership and the ability to develop the site. They will need to receive approval from the Watershed Property Review Board, as well as New Jersey Board of Public Utilities for the development of this property. That is an application process that the developer will lead and will go through. If they are successful, the property will then be developed with 195 units, or perhaps some variation if seen fit by the state agencies. So it's simply one additional hurdle that the developer must go through, unlike our other inclusionary housing sites that are up for discussion. This first site for our overlay zones is the Canoe Country Club. And so this is an overlay zone. What this means is that the zoning that will be put in place, which will allow for 8 units an acre with a 20% it can continue indefinitely if it so chooses. However, the zoning will be an option to the golf course should they choose to close. Next is our B2 zone. This is also on, I should say on Morris Turnpike. This is also an overlay zone. This means that the inclusionary zoning, which will be 18 units an acre with a 20% set aside, is an option to property owners and developers of these lands. This means that the existing commercial businesses may first remain in place, they may expand, they even have the ability to utilize their existing commercial zoning for new uses and perhaps redevelopment of their properties. However, the overlay zoning provides an additional zoning option for developers and property owners should they choose to cease the commercial use and instead utilize the inclusionary zoning at 18 units an acre. But importantly, they'll have to provide 20% of any affordable units as 20% of their units as affordable. Our next zone is the B2 zone along a portion of Millburn Avenue. And now, one of the things I think that is important is that this site actually includes one of our inclusionary housing districts as well, sites rather, the Annie Says property. And so this site will receive overlay zoning at 40 units an acre, again, with a 20% set aside. So just like I talked about on Morris Turnpike, developers and property owners can utilize the existing zoning for commercial uses if they're so inclined, or they can utilize the overlay zoning to include residential uses. But importantly, if they choose to do so, they'll have to provide a 20% set aside. Next, we have our B4 zone within, of course, downtown here in Millburn. This area will be rezoned as overlay zoning, once again, with the option to utilize that zoning at 25 units an acre with a 20% set aside. So the developer will have an option to utilize the commercial zoning or alternatively to work with residential or perhaps mixed use zoning in this area. Next, we have our Cmo District in the southern part of the township. This again is an overlay zone. Once again, it's an option in the way I've described multiple times. The zoning here will provide for 18 units an acre, again, with a 20% set aside. And I think last, but certainly not least, we have the Or1 District. This is off of, again, JFK Parkway towards the northern portion of the municipality. It's another overlay zone, so giving developers and property owners the option. The zoning in this area is 20 units an acre with that all-important 20% set aside. And so that is the totality of the sites included in our housing plan. We've talked, or excuse me, our settlement agreement. I went through a variety of sites that will named properties, individual sites that will meet the RDP, a couple of named sites that will meet the unmet needs, such as the Woodmont and the Dpw Site, and then a number of overlay zones. Now, like I said on the outset, this is really an important night, an important decision, but we're not done. The first thing we need to do pursuant to our settlement agreement and the court's direction is continue with the implementation of our two outstanding developers. That's the Woodmont and the Annie Says site. That means that the municipality is going to be required to introduce an ordinance in the near term so that we can advance those properties. One note I want to be very clear about on the Woodmont property that I did forget to mention. While the municipality is obligated to zone that property for the inclusionary development that's set forth in the settlement agreement, the developer is obligated to go to the Watershed Properties Review Board as well as the NJDPO. If they do not receive the necessary state approvals, the municipality zoning does not entitle the developer to any inclusionary housing or to any residential use. So that is a necessary step in order for them to activate the zoning, in order for them to utilize the zoning that will be put in place. And so that ordinance drafting and adoption will have to be coordinated with not only the developers, but also the court master to make sure that we're all moving in an acceptable direction for the court. Aside from that, the next step is the fairness hearing. we have to have the settlement agreement approved by the court. That will happen in the next couple of months, presumably. That will happen at a formal court hearing. It'll be publicly noticed, and there'll be coordination with Fair Share Housing Center, as well as the special master and the developers as well. Once our fairness hearing occurs and the judge presumably approves the agreement, at that point, it's time for the municipality to really put into high gear its implementation. That means that we have to put together a housing element, fair share plan, and that includes a variety of additional documents. So it's simply taking our settlement agreement and turning those, 5 pages or so of core information into a housing element that's probably 50 pages or more, and appendices that provide support for the individual sites, whether it's the zoning in place or administration documents to show how the affordable units will be compliant. There are a variety of documents that go into that housing element and fair share plan. Now, that document will need to be adopted by the planning board because it's actually a master plan element, the housing element. But it will also need to be approved by the council, as they will issue an approval for it to be submitted to court so that the court can review and approve it. Once we've submitted it to court, we go back to court, hopefully for the last time, and we have a compliance hearing where the court will review and presumably approve our housing element fair share plan. And at that point, we get a very important document referred to as the final judgment of proposal. And that is our court order that says that Millburn has satisfied its rehabilitation obligation, its prior round obligation, and its third round obligation. And we have immunity from builder's remedy litigation throughout the entirety or through the end of the third round. And at that point, we will have completed the court approval process. But I do want to be very clear that there are a variety of steps necessary in Millburn's settlement agreement that will be required to follow through between now and the next couple of years. And honestly, that's not unusual for municipalities in the state. Typically, settlement agreements really set in place a variety of steps necessary for a town to really fulfill its affordable housing obligation. And Millburn's settlement is no different. And quickly, I talked a little bit about what's in the housing element fair share plan, but I wanted to show this just for information so that folks know what's coming. Yes, it talks about what are the demographic projections, what are the employment projections, but it also goes through, obviously, how we're going to satisfy our obligation, not to mention what that obligation is, and a variety of supporting documents like implementing ordinances and administration manuals to ensure that those affordable units are actually compliant with the applicable rules and we get the credit that we intend to. With that, I'm happy to answer any questions.
Okay, thank you for your presentation. We're going to take a 5-minute recess,